Hello, my name is Ron Chapman, and thank you so much for joining us today. I'm the president and founder of Chapman Law Group, which is a national healthcare law firm that represents healthcare providers throughout the country. Today we're going to talk about qui tams. Qui tams is an interesting and very useful civil litigation tool. Qui tam actually means on behalf of the king. Back in feudal times, the king would have his subjects bring fraud claims where individuals were defrauding the king, and then he would reward his subjects. We mostly brought it into use during Civil War times. The government had commissioned shoes, for example, and they were delivered without soles, or commissioned bullets, which were delivered without gunpowder and were basically useless to the government. Today, it's kind of morphed into a number of things. It's used mostly for Department of Defense and for healthcare fraud. The government in 2023, I believe, recovered $1.7 billion in healthcare fraud. So a qui tam is a very useful tool for the government because it uses the individual, the private citizen, to basically be the watchdog. You identify fraud throughout the healthcare system. If you identify it successfully, you can bring a claim, and if that claim's successful, the relator will receive 15 to 30% of the proceeds that they'll actually share with their attorney. So let's begin. How does all this stuff come together? Well, first of all, you have to have a relator. A relator is the plaintiff, like we talked about, and the relator is basically an insider, somebody who knows the intimate workings of a healthcare practice, of a hospital, of a call center, let's say, well, basically any type of healthcare. Let's say a telemedicine, that would be a good example practice. And they gather information, they're looking around, they see that there's fraud being committed in a number of ways, so they begin to gather information to prove their fraud, and eventually they're going to work their way to an attorney. And what that attorney is going to tell them is the most important part of the relator's role in all this is to create enough facts to create what's called a disclosure statement. A disclosure statement is extremely important because it outlines the intricate details of the fraud that took place. Under the civil rules of civil procedure, fraud, since it's so easy to just allege somebody committed fraud, you have to have intricate facts and details. This insider, who's the relator, can pull all of those together. So let's use an example. And one of the examples to use is the False Claims Act. For those of you that like to look at details, the False Claims Act is 31 U.S.C. 3729, and the Qui Tam Act is 31 U.S.C. 3730. So false claims is often used in a qui tam, and the number one false claim that usually gets used is that you have to prove that somebody knowingly committed a false claim for payment. In other words, they defrauded the government in order to obtain payment. So if you have the details, and what kind of details do you need? You actually need the what, when, where, how, and who of who did the fraud. Quick break. If you're a healthcare provider or an entrepreneur involved in healthcare and have a legal problem, whether it's compliance, regulatory, DEA, criminal, or any number of legal problems, Chapman Law Group is here to help. Please visit us at chapmanlawgroup.com. Click the link below. Now back to the video. Let's use, for example, Incident 2. Incident 2 services are a process by which a healthcare provider can bill 100% for the services of a nurse practitioner or physician assistant. Typically, the nurse practitioner or physician's assistant only receives 85%. So there's additional 15% the physician can obtain. The critical part, though, or one of the critical parts, there's a couple elements to this, is the physician has to be present in the office to be available for discussions with the nurse practitioner or PA. Let's say, for example, you're one of the billers and you observe that the physician is not present. The physician is often gone away. The physician basically deals with their nurse practitioner or PA by telephone or by text message, and you know that this isn't appropriate for billing Incident 2. So you gather that information, and you're going to work with your attorney to prepare this disclosure statement. And in the disclosure statement, you're going to have facts and details. Perhaps you're going to have calendars. You're going to have billing records. You're going to have medical records. You're possibly going to list individuals that have intimate knowledge that might be willing to testify testify, and any other information that you can put together, and your attorney's going to use that to create this disclosure statement. And like we said earlier in this broadcast, the disclosure statement is extremely important because it's used by the U.S. attorney to determine whether or not they want to intervene in the qui tam. Now that's a little bit about what the relator does and doesn't do. Next, we're going to talk in part 2, and I hope you listen to part 2, about the details of how the qui tam and the False Claims Act work together. Thank you so much for watching the video. If you liked it, please hit that like button. It helps the channel. It tells YouTube to show this video to more awesome people like you. Hit that subscribe button and the little bell to the right so that you get notifications of more upcoming videos.